resuming debate. The Honourable Member for Vancouver Quadra.
Thank you, Madam Speaker, and I'll be splitting my time with the member for York West. Madam Speaker, I'm very pleased to be speaking to this motion today because of the important principles that are so fundamental to Canadian democracy. The motion calls on the House to recognize the fundamental right of all Canadians to freedom of speech, communication, and privacy, an affirmation of on the need for these rights to be respected. It talks about the Canadian Charter of Rights and Freedoms protections against unreasonable search and seizure. It talks about mentions that any legislation put forward by the government respects these provisions of the Charter and its commitment to the principles of due process, respect for privacy, and the presumption of innocence. Now, there's been some debate on this today, and a lot of the debate has centered on Bill C-30, and it'll be that bill that I address my remarks to today. And I just want to quote the interim leader of the Liberal Party, because what he said does capture the balance that Parliament needs to find on this bill, and that is, in quote, "The mark of a democratic society is how it balances collective security with individual rights and freedoms." And Madam Speaker, I am not at all objecting to the idea of strengthening the ability for the police to carry out their surveillance work and their investigative work in an age of internet and electronic communications. Surely we do need to update these provisions that are in the laws, and that's what this bill has sought to do. In fact, when the British Columbian Attorney General and Solicitor General came to Ottawa saying that they support the need for new powers, I supported that. That is something that we do need to do. And so the question is, really, does this bill achieve that end? And so that's what I will be speaking about, is the ways in which it does not find that balance, and the ways in which it does, whether inadvertently or deliberately, change the landscape for the public in terms of our security and our right to privacy of our information. And it does make changes through very vague language, vague concepts that are not well defined in the bill, that are open to subjective interpretation in terms of grounds for accessing people's information without a warrant. And people across Canada have been concerned about this. Not surprising when most of the freedom of information or the privacy commissioners across the country, nationally, provincially, said that this bill goes too far. This is a bad piece of legislation. And I'll quote the federal privacy commissioner, who said, in quote, "On balance, the new bill contains serious privacy concerns. In particular, we're concerned about access without a warrant to subscriber information behind an IP address. Since this broad power is not limited to reasonable grounds to suspect criminal activity or to a criminal investigation, it could affect any law-abiding citizen." And that's a mild comment compared with the comments of the Ontario Privacy Commissioner, who had a great deal of concern about this bill and called it an encroachment of surveillance as it's presently configured in the bill, who said that the bill is wrong, that said that it terrifies her. It could become the norm, that there is a huge downloading onto websites of information that service providers do because they are unable to serve the one-by-one requirements under this bill, and that's happened in other countries. And according to the Commissioner, this is fundamentally wrong. It flies in the face of freedom and liberty. And this freedom is not based on the state accesses whatever information they want on its citizens, which is how she characterized the potential result of this bill. No, the state is supposed to have a reason, and the collection of information from citizens is supposed to be limited and for particular purposes that are specifically identified to individuals. And her view is that that is under attack with this bill. And the bill creates a structure for this kind of widespread surveillance. Again, in quoting the minister, the Privacy Commissioner from Ontario, this is going to be like the Fort Knox of information that the hackers and the real bad guys will want to go after. This is going to be a gold mine. So she's also concerned about the new powers created for the police designed to obtain access to surveillance data and the whole framework that the companies will have to put in place installing equipment for real-time surveillance. So it's not surprising that given that response by privacy commissioners, who know whereof they speak, one would hope, that people in civil society became concerned and started to speak out. And in Vancouver Quadra, at the town hall that I hosted last week, I can tell you, Madam Speaker, people were very, very concerned about the change in the whole tenor of privacy under this bill. And with these kinds of reasonable concerns, it was that much more offensive and insulting when the Minister of Public Safety essentially said that either you agree with this bill and this government or you're on the side of child pornographers. That's a level of discourse that we cannot allow to continue in this House of Commons, and it actually really undermined any moral authority by that minister in terms of the bill as it was presented. It was ironic that afterwards the minister had to admit himself in public television that he hadn't read the bill and didn't actually understand some of its provisions and the repercussions thereof, and that is after having made that very offensive statement that he had made and that we're all familiar with. So this bill has had a rocky start. It was not properly thought out. The consultation was not properly done with privacy commissioners. I'm just going to give a couple of examples of concerns that I have. And these were raised by an internet business CEO and president at my town hall very clearly. Some of the previous speakers have talked to Section 34. I'm speaking about Section 372(1) and 2. And this is a place where the legislation creates a wide class of offenses that are vague in description, using terms that could be interpreted by law enforcement with an extremely wide range of discretion. And that's the nub of what people are concerned about. So under 372(1), it says, everyone commits an offense who, with intent to injure or alarm a person, conveys information that they know is false or causes such information to be conveyed by letter or any means of communications. Well, so that's actually pretty subjective. How does one define an intent to alarm a person? I mean, that could be a phone bank calling into the constituency of Mount Royal, for example, and saying, do you know your member of parliament has stepped down? That could be an alarming piece of information. So whoever made those calls actually would be committing an offense under this and would be liable to imprisonment for up to 2 years. I hope the members on the Conservative side of the bench really let that sink in. It conveys information they know is false with the intent to alarm a person. That would be against the law with a jail sentence. But think about how widely that could actually be interpreted. Here's another one, 372 subclause 2. Everyone commits an offense who, with an intent to alarm or annoy a person. So has anybody in the Conservative benches ever sent an email with some intent to annoy someone? Well, that actually would be an offense if it is accompanied by, if they are making an indecent communication to that person. Well, who is defining what is decent and indecent? Some people think that A photo of clothing that is too tight might be indecent. What about a swear word might be considered to be indecent? So if a member opposite sent an email intending to annoy with something that communication that was indecent, they would be then committing an offense and subject to 2 years, up to 2 years in prison. So I think I'm making my point that
Order, please. Order. The honourable member's time has elapsed, and perhaps she can add some more comments and questions and comments. The honourable member for Kitchener-Conestoga.
Okay. Well, thank you, Madam Speaker. I listened with interest to most of the speech as it was being given, but the rhetoric, the fear-mongering, she uses terms like it was not thought out, there was not adequate consultation, and yet, Madam Speaker, just a few years ago, Deputy Prime Minister, the Honourable Anne McClellan, Minister of Public Safety, tabled this same bill, and she said, we consulted extensively to ensure this legislation strikes the right balance. So, and she goes on. So my question is simply this. Was Anne McClellan wrong, or was she lying?
The honourable member for Vancouver-Quadra.
Speaker, the member that under the Liberal government, even Liberal members sometimes disagreed with their government and voted against them at committee. That would never be allowed in this government. This government doesn't allow its members to disagree. So these things would have been hashed out in committee in a way we have seen is not able to happen under this over-controlling and dictatorial government. And another point, Madam Speaker, is it is a matter of trust. This is a government that has lost the trust of the public. It has muzzled scientists. It muzzles independent officers of Parliament and civil society by cutting funding off those that don't agree with it. It's trying to muzzle MPs. We won't let that happen. And this bill would be putting a chill on the debate and the marketplace of ideas happening in the Internet, and it would be an attempt to muzzle.
Order, please. Order, please. I see many MPs rise. The honourable member for question and comments for Thunder Bay Superior North.
Thank you very much, Madam Speaker. Madam Speaker, in 2002, the Liberal government at the time did launch consultations, but they don't seem to have listened to them. They received feedback from privacy and information commissioners across Canada that, quote, the proposed measures go far beyond what is necessary to maintain existing capabilities and authorities in the face of modern communications technology, close quote. So, Madam Speaker, my question to the honourable member from Vancouver-Quadra is, why, given this feedback, did the Liberal government continue down the path to creating legislation with measures that they are today criticizing, like warrantless access provisions?
The honourable member for Vancouver-Quadra.
Well, thank you, Madam Speaker, and I'm frankly surprised that this member is calling on me to justify something from 10 years ago in a government that I wasn't here for. In fact, this debate that we're having now is one that is raising some very serious issues, and my concern is that despite the good intentions of the NDP members and the Liberal members, the Conservative members might do what they have been doing for the last 7 months, which is to barrel ahead with bad legislation and ignore all of the input from civil society and from members of Parliament to improve the legislation so it actually delivers a public good.
Questions and comments? Questions et commentaires? L'honorable.
The honourable member for Ahuntsic. Thank you, Madam Speaker. I would like to ask my colleague what she thinks of the provisions in this bill giving the Canadian Security Information ceases the possibility, as well as other agencies that are not police forces, these special powers. We learned recently that the government had issued a directive to CSIS to use information obtained by torture.
It's 1 minute.
Merci pour cette question.
Thank you for that question. This is a matter of great concern. This use of information obtained through torture. There's also the fact that the Minister of Public Safety announced that environmentalists, these activists on animal rights, are on the list for the anti-terrorism strategy.
Puts a great chill on those organizations' ability to communicate, but also in Section 184.4, a peace officer may, without a warrant, may intercept communication if the peace officer has reasonable grounds to believe that the urgency of the situation is such that it's necessary. But who defines that? I mean, the Prime Minister has said that a particular pipeline is in the national interest. Could that be part?
Unfortunately, the honourable member's time has elapsed. Resuming debate, the honourable